In the interest of Alyssa Solis and Annalisa Solis, we are here set for our trial today. We are conducting this through Zoom under a finding of good cause and agreement of the parties. I'll address some more about that here in just a minute. We are live streaming, and Ms. Corbin is making our record for us today. All right, we'll go ahead and take announcements, and then I want to get some information on the record.
Yes, ma'am. Daniel Trout for the Texas Department of Family and Protective Services. We're present, ready, Your Honor.
Savannah Kincaid, I represent Ms. Pineda. We're present and ready.
Gary Morales for respondent father Neil Solis, Your Honor. We are present. He is ready.
Stacy Zabala on behalf of the girls.
Donna Rowland with Emerald Casa. With me, I have Julissa Castillo, who's the Casa advocate.
All right, thank y'all very much. Okay, I just want to address an issue on the record. And I'm going to ask Ms. Katie to also give some specifics and particulars about this, because she's the one that was handling a lot of this. As everybody knows, when we set this final, I requested that we would do this as an in-person trial, which we fully intended to do and have Mr. Solis bench warranted in. And I believe that bench warrant was issued back in March. I'm going to let Ms. Katie give the specifics of what we know about that and why we have had to shift very quickly to doing this by Zoom. I want Mr. Solis to know what efforts were made to try to have him brought in. And I just want that on the record. So, Ms. Katie, if you would just sort of outline the events that led up to us doing this by Zoom today.
Yes, Judge. Do you want my video on?
No, you don't necessarily need to turn on.
We had issued a bench warrant to the WIN unit. That was the unit that Mr. Solis was in back in March. And then I checked Monday to see if they had brought him in for this hearing, and Potter County was not showing him to be on their roster. So then I checked the TDC website, and it showed that Mr. Solis had been transferred to the all red unit. So at that point, I contacted the all red unit to see if they had any kind of transport request from Potter County to have him brought in for this hearing. And she said no. So at that point, I decided that it would be best to try and make arrangements to have him appear via Zoom, because normally the transport requests are put in fairly early on so they can make sure that the clients are transported in a timely manner. So I started working on that, and then I got an email from Potter County Sheriff's Office saying that they were unable to execute the bench warrant because Mr. Solis had been moved from the WIN unit, and the bench warrant was specific to that unit. So in the interim, I had contacted the all red unit to find out who I needed to contact to have Mr. Solis appear via Zoom. And they sent me an email address to the department that handles the video portion of inmates appearing via video. And I got an email back from them stating that they were unable to accommodate that because we had not given them adequate notice of him appearing via Zoom. I think it was 14 days notice, I believe is what the email had said. So then I contacted the all red unit, and they told me that he was able to appear via phone. So that is why we have Mr. Solis appearing by phone today.
All right. And to further complicate all of this, of course, our dismissal date is tomorrow on April 18th. This case has gone into extension, so that's the absolute drop dead date. I will tell everybody that Ms. Katie and I did look at the court calendar. We were not able to find another full day to set this case, assuming we did a call and a recess on it. But we were not able to find another full day that we could devote to this case within the statutory 90-day requirement. So it was my decision that we absolutely have to proceed today to stay within our deadlines. And so, Mr. Solis, I'm sorry that was the set of circumstances. You had not requested to be bench warranted in. That was the court's decision. But we were unable to get that accomplished, and so we will do the best with this that we can by telephone. So since you're going to be on the telephone, that we're certainly limited to some things as far as I can't see you when I swear you in and those kinds of things. But if at any time you need to speak with your attorney, all you need to do is just tell me that. Even if we're in the middle of something, you can just tell me that, yes, you need to talk to your lawyer. So you understand all of those things today,
So
Mr. Solis?
I just say, I need to speak to my lawyer, Your Honor. That's all I got to say.
Yeah.
Okay. Yes, ma'am.
Just let me know, and we'll put you back in a breakout room where you can speak with him privately.
Yes, ma'am.
Okay. All right then, Mr. Trout, does the department have anything we need to, or we have any other procedural issues we need to cover before we get started today?
I don't think so, Your Honor. We'll take some testimony as to what we had discussed between the attorneys and in a bench conference, and we'll take testimony on that, how we'll start.
Okay, very good. All right then, who's your first witness going to be today?
Avery Hoganson, Your Honor.
Okay, Ms. Hoganson, if you will, please raise your right hand for me. You solemnly swear or affirm that the testimony you'll give today will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right, thank you, ma'am. All right, you may proceed.
Thank you, Your Honor. Ms. Hoganson, would you state your name for the record, please?
Avery Hoganson.
And Ms. Hoganson, how are you employed?
I'm employed with St. Francis Ministries as a permanency specialist.
And you are familiar with the case on the Solis children that we're here on today, correct?
Correct.
And how are you familiar with that case?
I am the permanency specialist on the case.
Now, in regards to mother, how is mom doing at this time?
Miss Pineda is doing really well. She has completed all of her services outlined on her family plan of service. The visits with the girls go really good. They're bonding. She's doing really good. She has stable employment. She has stable housing. She's doing good.
Are we having any issues as far as transportation and financial situation right now?
Yes.
Okay, and what are those?
Miss Pineda is having trouble paying off remaining charges to reinstate her driver's license. That's the only barrier that's getting in the way of her obtaining that. So in order to help her obtain her license, St. Francis Ministries is willing to pay her rent for the month of April to help her alleviate some of that stress.
Okay. And with mom not having being able to drive and having transportation for that, we're having issues. If children are placed back with mom, then mom can't transport at this time. Is that correct?
Correct.
Okay. And is mom getting rides from others or using public transportation at this time? How is she getting around?
She typically uses Ubers and Lyfts.
Okay. And so you stated that the department's helping her pay some of her bills so that she can reinstate that license.
Correct.
Okay. Where are we on? So we mediated this case, is that correct?
Correct.
Okay. And this case was mediated back in about the third week of September?
Correct.
Of 2024?
Yes.
Okay. And at that time, we were nearing the final hearing in that case. Is that correct?
Correct.
At that final hearing, the case was extended.
Correct.
Okay, which puts us at the final hearing today, correct?
Correct.
Okay. So since September, when the mediated settlement agreement was entered or everybody agreed to, at that time, it was an agreement for the department to take permanent managing conservatorship.
Correct.
And
Mr. Trout, let me interrupt you real quickly because I've reviewed the mediated settlement agreement. Mr. Solis did not agree to this. And I think you just said on the record, everyone agreed. If you'll just clarify.
yes, ma'am. Yes, ma'am.
Okay.
Ms. Ogenson, at that mediation, parties were present, correct?
Correct.
As to Dad, Mr. Solis, he did not enter into this agreement. Is that correct?
Correct.
Okay. He did not finish out the mediation. So the agreement, as far as the mediated settlement agreement, was only in regards to Mom.
Correct.
Okay. And so just straight out, Mr. Solis was not a party to the mediated settlement agreement.
Correct.
Okay. So at that, there was an agreement with Mom that the department would take permanent managing conservatorship.
Correct.
That Mom would be a possessory conservator.
Correct.
There was an agreement at that time for child support.
Correct.
That child support was set per the mediated settlement agreement to start in November of 2024, correct?
Correct.
And that was based upon the thought that we were going to be entering a final order back in that time.
Yes.
Okay. There was also kind of a step up visitations with Mom to work with her on visits.
Correct. Yes.
Since that time, and since the settlement agreement has not been entered due to it not being a final order, it's kind of been a fluid situation, correct?
Yes.
Okay. Mom has continued to work with the department
Yes.
and has worked through her services, as you've stated.
Yes.
We just have the few final things to tidy up. Is that correct?
Yes, sir.
Okay. Where are we on visitations? What is going on with visitations with Mom?
Currently visitations with Mom. When the girls are with their Aunt Linda bi-weekly on the weekends, Anna does get 4 hours. Recently we did do a plan to reunify to increase those hours with Aunt Linda helping transport the girls in St. Francis Ministries, transporting the girls to and from. And those first started out with unsupervised visits, starting at 4 hours, and then the next week at 6 hours, and then the next week at 8 hours. And all of those visits have been reported to go really well.
But at this time, we're still stepping up some visitations.
Yes, sir.
And we are not ready to fully return the children to Mom due to transportation issues and still working through step-up visitation plans.
Correct.
Are you
Mr. Trout, I'm going to interrupt you again. I'm so sorry. Ms. Pineda, I just realized you don't have your video turned on. Can you do that for me?
Yes, ma'am.
Okay, thank you. All right, Mr. Trout, go ahead. I apologize.
That's all right, John. Ms. Hoganson, today, in regards to Mom, are you asking the court, due to the fluid situation of what has happened since the mediated settlement agreement, are you asking the court to still determine and give the department permanent managing conservatorship?
Yes.
To step away from the mediated settlement agreement and not order child support and medical support at this time due to Mom's financial situation.
Yes.
And for Mom to be awarded possessory consent.
Yes.
And to that will allow the department, since we're at the end of the case, to continue to work with Mom and work the children back in a reunification, and at a later date modify as long as everything goes well.
Yes.
And once we hit the point of full reunification with Mom, we can modify to give Mom permanent managing conservatorship is the plan.
Yes, sir.
Okay. And that is barring any issues that could arise. Hopefully they won't, but as long as everything goes smoothly as it has been, that is the plan.
Yes, sir.
As far as the visitations in the mediated settlement agreement, there was a stipulation that mom was to continue to work services and have drug screens, alcohol screens continue. Is that correct?
Yes, sir.
And if during any of the step-up visitations, mom tested positive, the visitation would go back to supervise. Is that correct?
Correct.
Okay. Would you ask that that caveat still stay, that if during the PMC stage, still working with mom, if we have any positive screens, that we would have to back up and go into supervised visits again for a little bit?
Yes, sir.
But this is all due to still wanting to work, willing to work with mom to try to reunite the children with her.
Correct.
And is that what you would be asking the court to grant this today?
Yes, sir.
And do you believe that's in the best interest of the children?
Yes, sir.
How are the children doing right now?
They are doing great. They're both doing amazing in school. When I talk to them, they report that they really enjoy their visits with their mother and they like hanging out with her and just being around her.
Are the children currently in a permanent placement?
No.
So this what you are asking today would be the best option moving forward to reunite with mom to get the girls in a permanent situation.
Yes, sir.
And you do believe that is what's in the best interest of these children?
Yes, sir.
Thank you, ma'am. I'll pass the witness, Your Honor.
Mr. Morales, excuse me, Ms. Kincaid, I'm going to let you go first. I apologize.
Judge, Ms. Hoganson, would you agree that Ms. Pineda has been cooperative with the department?
Yes, ma'am.
And since the time of the mediated settlement agreement, she's made substantial progress in working with the department. Is that fair to say?
Yes, ma'am.
Do you think that there's been a material change in circumstance since the time of that mediated settlement agreement such that it would be appropriate to amend it so that Ms. Pineda can work on her financial situation?
Yes, ma'am.
Do you think it's in the children's best interest that we make that modification so that she doesn't need to pay child support so that she can take care of her driver's license?
Yes, ma'am.
Thank you. I'll pass the witness.
May I speak to my lawyer, please, Your Honor?
All right, Mr. Morales, I will put you because he doesn't have the ability to move himself around. I'll move you to a different room. I'm gonna put you into room 4 and I'll put him in there with you.
Okay, Judge. Thank you, Judge.
Okay, Mr. Morales, do you have any questions for this witness?
Yes, briefly, Judge. Ms. Hoganson, as a permanency specialist, is it part of your duties to review the entire CPS history of both parents?
Correct.
Okay. And as your role of permanency specialist in this case, were you able to do that for the parents as well?
Correct. Yes, sir.
And additionally, is it also your duty to prepare the permanency reports that go out to the court before each hearing?
Yes, sir.
And in fact, you did the most recent permanency report for this final hearing. Is that correct? Your name's on that, signed as a permanency specialist?
Yes, sir.
Okay, I had a specific question on page 4. About halfway through the chart where it's listed neglectful supervision and physical abuse of one of the children, and you can see that, and it's the only allegation post 2012 with Neil Solis Sr. Do you see those 2 allegations dated February 5th, 2023?
Yes, sir.
Okay. Is it your understanding that Mr. Solis has been incarcerated continuously since 2020?
Correct.
So can you specify, and I may be lost, I was behind on this case. I was substitute counsel, I think you're aware of that. What were these allegations supposedly occurred in 2023? Because obviously that couldn't happen if he was in prison.
No, that might have been my mistake putting that on there.
So do you think that that shouldn't be listed at all, or do you think there was a mistake in the date?
It could have been a mistake in the date, or it shouldn't be listed at all.
Okay, we're just not sure.
Correct.
But it is clear though that he's been incarcerated since 2020, and with that being the case, for this particular removal, he was a non-offending parent. Would we agree with that?
Yes, sir.
Okay. And were you in contact with Mr. Solis while he was at the WIN unit?
I was for a brief period.
Was there any individuals with the WIN unit that corresponded, or it was their job as the personnel there to work with CPS to get services set up?
Yes, I had attempted to call them twice. I believe on the second time she told me she would get back to me and never did.
Okay, and so with that being the case, you'd agree with me that services were never provided by and through the WIN unit for Mr. Solis,
Correct, yes, sir.
but they were in fact available.
Yes, sir.
And as far as you know, did he indicate both to the WIN unit and any time that you contacted him that he was ready and willing to participate in any services that he could while he was incarcerated?
Yes, sir.
Okay. I'll pass the witness.
Okay, Ms. Ball?
I have no questions at this time.
All right, Mr. Trout, any further questions of this witness?
Just real quick, Your Honor. Ms. Hoganson, as to today, what we're working to accomplish today, in regards to mom, you've already testified to what you're asking the court for today with mom, correct?
Correct.
You're asking for the PMC to the department of primacy or possessory to mom with the modifications to the MSA that we've discussed.
Yes, sir.
As to dad, the department will be requesting termination today. Is that correct?
Correct.
Okay. I'll pass the witness, Your Honor.
All right, anybody have any further questions of Ms. Hoganson?
Just briefly, Your Honor, one question. Do you know the date of Mr. Solis' projected release from prison?
I don't know the specific date, but I believe it's sometime in 2032.
Okay, thank you. I'll pass the witness.
All right, anybody else have any other questions for Ms. Hoganson?
Can you speak to my lawyer, please, Your Honor?
Can I get one follow-up question to that, Ms. Kincaid's question?
You certainly can, and then your client's wanting to speak with you.
Okay,
Mr. Solis, can he ask his question first?
Yes, ma'am. Yes, ma'am.
All right, Mr. Morales, go ahead.
Ms. Hoganson, the projected release date is 2032. Are you looking at from the TDCJ website?
Yes, sir.
And does that website also indicate that he is also currently eligible for parole as of 2024?
Yes, sir.
Okay. And are you do you have any familiarity with the parole system?
I do not know.
Okay. So theoretically, he could be paroled at any time between now and 2032 as well, if he's eligible. Okay. I'll pass the witness, Judge.
All right, Mr. Solis, do you still need to speak with him?
No, ma'am.
Okay. All right, anybody else have any questions for Ms. Hoganson?
One follow-up, Your Honor, and we'll go ahead and take care of this. Ms. Hoganson, based upon that website that you talked about, the TDC website, his projected release date is in 2032. Is that correct? That's what you
Yes,
just said?
sir.
Okay. But he has do you know when his max sentence date is?
His maximum sentence date is in 2045.
Okay. All right. Thank you, ma'am. I'll pass the witness, Your Honor.
All right, anybody have any follow-up questions?
There you are.
No.
All right, then.
I would just ask Your Honor to keep Ms. Hoganson, she'll be recalled at a later time.
Okay.
But to keep her present with us and under oath.
All right, I assumed that she would need to remain since she's the permanency specialist, so. Okay, then. All right, you may call your next witness.
Mercedes Hodge, Your Honor.
All right, Ms. Hodge, if you'll, do you have video? There we go. All right. If you'll raise your right hand for me. You solemnly swear or affirm that the testimony you'll give today will be the truth, the whole truth, and nothing but the truth.
Yes.
All right, you may proceed.
Thank you, Your Honor. Ms. Hodge, would you state your name for the record, please?
Mercedes Hodge.
Ms. Hodge, how are you employed?
I'm an investigator with Child Protective Investigations.
And are you familiar with the case involving Alyssa and Alyssa Solis that we're here on today?
Yes.
And how are you familiar with that case?
I was the investigator that initiated the removal in the beginning.
Could you tell us, how did the department become involved in this case?
On where I got involved, is that what you were asking?
Yes, ma'am. How did the department end up in this case?
There was an incident where there was a domestic violence incident between Ms. Pineda and Mr. Richardson, where the children left the home seeking safety.
And just to clarify, you said Mr. Richardson.
Yes.
He is father of a child in another case. Is that correct?
Yes, he has a child with Ms. Pineda.
Okay, all right. So how did your investigation proceed? What did you do? What were your first?
When I initiated the case, the children were not in Ms. Pineda's care. She had placed them with other people. And then we went through kinship placement eventually because the two girls were in San Antonio with fictive kin.
Okay. And how did you make contact with mom, Ms. Pineda?
Yes.
And when did you make contact with her?
That would have been on October 11th of 2023.
Okay. And what was your conversation with her at that time?
Ms. Pineda admitted that, there was an incident that happened in the home and that she did send the children away due to that incident, concerns that the department would get involved again. She admitted that she understood Mr. Richardson was not supposed to be in the home due to previous concerns.
Was there Mr. Richardson not being allowed in the home, that was due to another ongoing CPS case with mom, is that correct?
Correct.
Okay. And that case was still an active case at the time of this removal?
Yes.
Mom state that they had an argument? Is that correct?
Referring to who? I'm sorry.
Say again?
Who are you referring to?
Did mom state to you that there had been an altercation or an argument?
Yes.
Okay. And did mom state to you that she went to check on the girls and they were gone?
Later on, yes, that night.
Okay. Did she tell you what the argument was about?
I don't think that she understood what the actual issue was. I know that there was some drinking going on. And so I don't think she was clear on exactly what the argument was about. Okay.
But mom knew, due to her other case, that Mr. Richardson was not to be in the house around the children.
Absolutely.
And was part of that, not only domestic violence, but drug use.
Yes, Mr. Richardson had previously tested positive for cocaine.
Okay. And the children were placed out of county with a friend, correct?
Yes, by Miss Pineda.
Okay. Was there concern in reason for removal, concern of mom wanting the kids back in Amarillo at that time?
Yes. At first she did place the kids there, but then on October 17th, we were informed that she was requesting her kids to be brought back to her in Amarillo.
Okay. And due to the incidents and what was going on, that was a concern for the children's safety?
Yes.
During your investigation on this case, did mom or did you discover who dad was?
Yes.
And who is dad of these two children?
Neil Solis.
Okay. And where was Mr. Solis at the time of the removal?
He was incarcerated.
Okay. Do you know how long he had been incarcerated?
I do not know.
Okay. But he was in TDCJ at that time?
Yes.
Okay. Were you ever able to speak with him during your
No, I
investigation?
was not.
Do you know what he was incarcerated for?
Some of it, I believe. I'm a little confused on it, but I do know the gist of it.
Okay, and what was that?
I know that there's delivering controlled substance, and I
Okay.
believe that's the 25-year sentence.
Okay. Your Honor, I would ask to admit exhibits number 2 and number 3. They are certified copies of the indictments and judgments for Mr. Solis's current charges that he's incarcerated on.
No objection.
No objection?
No objection.
All right, petitioners exhibit 2 and 3 will be admitted.
Thank you, Your Honor. Ms. Hodge, you stated that, I believe you just said he was on a controlled substance delivery charge with a 25-year sentence. Is that correct?
To my knowledge, yes.
Okay. And you heard testimony earlier that his projected release date's not until 2023?
Yes.
And max date is in 2045, I believe it is.
2022, I think. Yes.
Okay. And that is, he was incarcerated at the time of the removal and has a projected date of further than 2 years from the removal. Is that correct?
Yes.
And these charges are charges that are on his own behalf. I mean, he committed these crimes himself, correct?
Yes.
Okay. So due to that, concerns with mom wanting the children back in town and what had conspired as far as the domestic violence and somebody being in the home that was not allowed, and dad being incarcerated at the time, removal was necessary at that time. Is that correct?
Yes.
And that was necessary for the safety of the children, correct?
Yes.
Now, in the incident of the removal, the incident that led to the removal, dad was not offending at that time, correct?
Correct.
Okay. But not non-defending in the fact that he was incarcerated due to his own actions.
Correct.
And again, you believe the removal at that time was in the best interest of the children for their safety.
Yes.
Thank you. I'll pass the witness, Your Honor.
All right, Ms. Kincaid.
No questions, Your Honor.
All right, Mr. Morales.
No questions, Your Honor.
Can you switch my lawyer, please?
All right, Mr. Morales, I'll move you all. Okay, Ms. Corbin, you're gonna have to remind me where we were.
I think we just finished up with Mr. Trout's.
Questions for Ms.
Correct.
Higginson?
Yes, and Mr. Morales had said he had no questions before we broke out.
All right.
And Your Honor, my client, we discussed, I'd like to ask a few questions if I could, please.
Certainly, no problem.
Would you like me to proceed?
Yeah.
Okay, I'm sorry, Jane.
No, it's no problem.
Ms. Hodge, as the investigator, were you able to review the notes of all previous investigators?
Not in depth. I wouldn't remember everything from previous cases.
Okay. What about the contacts that investigator Stutz made to Linda Del Toro? Are you aware of that conversation?
Oh, in this investigation, yes.
Okay. And in that investigation, was it reported that Anna has lied repeatedly to the department?
Objection, Your Honor. I think that's speculation.
Sustained.
Was it reported that the children bounced from home to home from multiple times while in the care of their mother.
Yes.
And that it was mother's choice to place at the stepfather house where the children were repeatedly abused.
That's what she reported.
Okay. And did you investigate the accuracy of those allegations? And in fact, the individual, and I think we're on YouTube, so I'm not trying to get into specifics, but the individual that allegedly abused them, did you investigate into that?
I was not the investigator on that.
Okay. Are you aware of whether or not the individual received any disposition of his criminal charges? I believe the report says that he had grand jury tomorrow, so this would have been in 2023. Are you aware of that this individual's whether or not he was adjudicated for any charges against the children?
I'm not sure of that.
Okay. I'll pass the witness.
All right, anybody else have any other questions for Ms. Hodge?
No, Your Honor.
No,
All right. Any objection to Ms. Hodge leaving at this time?
No, Your Honor.
no objection.
No objection.
All right, then, Ms. Hodge, thank you for your appearance today. You're free to go at this time.
Thank you.
All right, Mr. Trout, next witness.
Call Neil Solis, Your Honor.
All right, Mr. Solis. I know that you can't see me, nor can I see you, but will you raise your right hand, sir?
Yes, ma'am.
All right, do you solemnly swear or affirm that the testimony you'll give today will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, sir. Okay, Mr. Trout, you may proceed.
Thank you, Your Honor. Mr. Solis, would you state your name for the record, please?
Leandro Solis, Senior.
And you are the father to Alyssa and Alyssa Solis, correct?
Yes, sir.
Okay. Now you heard some testimony earlier and some exhibits that came in, but you're currently incarcerated, correct?
Yes, I am incarcerated right now.
Okay. And one of your charges is a possession with intent to deliver of a controlled substance, correct?
Yes.
Okay. And on that charge, you were sentenced to 25 years, correct?
Correct.
Okay. And your other charge that you are incarcerated on is an unauthorized use of a vehicle?
Correct.
And you were sentenced to 7 years on that charge, correct?
Correct.
Okay. Were you originally on community supervision for that charge?
Correct.
Okay. And then you were put on, let's see, community supervision in March of 2020?
I was put on supervision in 2020?
Yes, sir. When you first went on probation.
No, that's not correct.
Okay.
You have the date wrong. I was put on probation. You have that correct, but you have your date wrong.
Okay. The date the judgment was entered was in March of 2020.
That was my sentence date, correct, but you asked me if I was on probation in 2020, and that's not correct.
Okay. And then you were revoked off of probation in 2021. Is that correct?
No, sir. I was revoked on probation in 2020 when I got my 25-year sentence in 2020, sir.
Okay. Your Honor, I'd ask the court to take notice the exhibit number 2 that was entered, the judgment of conviction placing the defendant on probation. The date of judgment entered on that document is March 20th of 2020. And the judgment revoking community supervision, the date of that judgment was February 26th of 2021.
All right, counsel, any objection? It's already been admitted as an exhibit, so.
No objection, Your Honor.
No,
No
Your Honor.
objection.
All right, the court will take judicial notice of those dates.
Thank you, Your Honor. So, Mr. Solis, at the time of the removal, you were incarcerated, correct?
Yes.
And you have been for the life of this case, correct?
Yes, sir.
Okay. And there's a possibility of your incarceration past 2 years from when we removed the children, correct?
What was that again? I'm sorry, I couldn't hear.
So your incarceration is going to last longer than 2 years from the time we removed the children.
Yes, sir.
Okay. Now you do have chances for parole, is that correct?
Every year, yes, sir.
Okay. You were denied parole in October of 24, is that correct?
Yes, sir.
Okay. Mr. Solis, do you have other criminal history?
Yes, I do.
Okay. And have you also in 2014, were you convicted of a injury to a child?
Correct.
And you did 5 years on that?
Correct.
Okay. And was that injury to a child, was that your child?
Correct.
No, I'm gonna object as too remote. This is more than 10 years ago.
Your Honor, I understand that this conviction is more than 10 years ago. However, one of the grounds for termination is that he has a conviction or has been placed on deferred for a laundry list of charges, this being one of the charges. I don't believe anywhere in the statute it states as far as for termination grounds how remote that can be.
Okay, I'm going to allow questions, so I'll overrule Mr. Morales' objection.
There you go. And Your Honor, with that, I would ask to admit exhibit number 1, which is the indictment and judgment for the charge that we were just discussing of the injury to a child.
All right, counsel.
Yeah,
No
just for the
objection?
record, I made the same objection, just too remote.
All right. And I'm going to overrule it based on the laundry list of offenses that are contemplated under chapter 161. All right. I think I heard somebody else. Ms. Kincaid?
No objection for me, Your Honor.
Okay.
No objection for me.
All right. Petitioner's exhibit 1 will be admitted.
Thank you, Your Honor. Your Honor, I'd also go ahead and ask to admit exhibit number 5. It's a self-authenticating printout from the TDCJ website as far as the inmate location information, and that states his sentence dates and projected release dates.
Any objection?
No objection.
No objection.
No objection?
All right, petitioner's exhibit 5 is admitted.
Thank you, Your Honor. And Your Honor, on that exhibit, asked the court to take notice that Mr. Solis's maximum sentence date is September 22nd of 2045, and his projected release date is February 6th of 2032.
Okay, so noticed.
Thank you, Your Honor. This time I'd pass the witness, Your Honor.
Thank you.
All right, Ms. Kincaid,
No questions, Your Honor.
Mr. Morales.
Your Honor, while we're on exhibit 5, I'd ask the court to take judicial notice that on exhibit 5, the inmate parole eligibility date reflects August 3rd, 2024.
All right, duly noted.
Thank you, Your Honor. Mr. Solis, you testified that you've been incarcerated the entire time. You're aware that I wasn't your attorney in the beginning of this. Have you had an opportunity to review the affidavit of removal?
Yes.
Okay. And you and I have only had a few conversations since I was substituted so late, but you've expressed a number of concerns with the kids in honest care. Is that right?
Yes, I have.
And are they based on your personal knowledge of their situation and also of the affidavit of removal?
Yes, uh-huh.
What concerns do you have, Mr. Solis?
Well, where to begin? The concerns I have is just the repeated lies, and placing my girls in a home and an environment where they were abused, and the department knowing these things and not protecting my girls. And I know.
Objection, Your Honor. It's speculation unless he has personal knowledge of any of this.
Yeah, and we're
Yes,
getting
I do.
kind of, this is dangerously getting into a narrative. So I think, Mr. Morales, let's just try to ask him some very specific questions if you can.
But there is,
Mi-
but there
Mr.
is.
Mr.
but there
Solis,
is-
One second,
Mr.
Mr. Solis.
Mr. Solis, hang on. All right, Mr. Solis, there's a proper way to give testimony and an improper way. So Mr. Morales is going to ask you some very specific questions. Answer those questions as he asks them. He'll get through everything he thinks he needs to ask you, but we can't just have a long rambling answer. Okay.
Instead of rambling answers, it's evidence that
Mr.
there's evidence
Solis.
stated
Okay,
in the document.
We'll get it, Mr. Solis. Just give me a chance to ask individual questions is all they're asking, okay?
All right. And Mr. Solis, I muted you because the court reporter cannot take down what I'm trying to say and what I'm ruling on when you're interrupting me. It's impossible for her to take both of us at one time. So don't interrupt me when I'm issuing a ruling or I'm trying to give some instruction to someone in this courtroom. You understand? You can unmute now. If you want to address me, you'll need to unmute. Okay. Do you understand?
Yes, ma'am.
Okay. All right, Mr. Morales.
Mr. Pineda, I'm sorry, Mr. Solis, you stated that you have access to the affidavit of removal. Do you have, you're aware that the Ms. Pineda admitted that she allowed Mr. Richardson back into the home after knowing the risk to the children due to previous drug use and domestic violence? Are you aware of that?
Yes.
Does that cause you concern that she allowed an individual who not was only violent with her in the past, but was also a drug addict back into the home with your children?
Along with possible harm being done to my daughters, yes.
Okay, now possible harm, and now he is not biologically related to your children, is that correct?
Correct.
Has Ms. Pineda also put your children in homes where they were repeatedly sexually assaulted?
Your Honor.
Yes.
Objection.
Your Honor.
Okay. Hold on. Ms. Kincaid was first. What's your objection, Ms. Kincaid?
Well, in the first place, if we're going to go into that, I'd like to be taken off of YouTube. But my objection is that he has no personal knowledge of that.
All right.
And Your Honor, I would second that objection, based on those events are not part of this removal.
All right. Mr. Trout, you were going to add to?
Same objections, Your Honor.
Your Honor, my reply would be that if the department is going for termination, Mr. Solis's major concern is going to be the future protection of his children. It might be a long shot that he gets out in time, but his concern is to know that Ms. Pineda is going to be protective in the future as well.
And I'm going to give Mr. Morales a little leeway here, but Mr. Morales, he can only testify to what he has personal knowledge of. So, I mean, I think we need to lay some predicate and some foundation on some of these things, not just ask him and if he has some secondhand knowledge of it or because somebody told him something about it.
May I ask a question?
You may ask me a question, yes.
If it's inside of a CPS court document investigation, that's not knowledge. I mean, that's not considered facts. I mean, it's supposed to be facts, correct?
I mean, your attorney he's obviously gonna phrase his questions.
Okay, ma'am.
That would be geared towards what your knowledge would be.
Okay, yes, ma'am.
There's, what somebody else tells you or says to you, generally speaking, is hearsay, but it depends on whether they're a party to the case. It depends on what kind of statement it is. There's a lot of rules that involve that. And Mr. Morales.
But I have personal knowledge that this happened.
Okay. Well,
not this.
Okay,
Not
Mr.
this
Solis.
specific. I'm sorry.
Okay. Just let your attorney ask questions and we'll get there.
Yes, ma'am.
Judge, did you make a ruling or decision on the YouTube thing? Do I need to wait?
Well, I guess the question is how very specific are we going to get? I mean, this is a final hearing. Generally speaking, this needs to be open to the public.
Your Honor, I understand.
As much as I, hate the implication of some of that, but
Judge, I'm not real sure how specific my client's going to get as to what his personal knowledge is. I have no clue what his personal knowledge is outside of what he knows outside of the affidavit.
Judge, I'd make a motion that if we are going to go down this road, in the instance of being safe as far as protecting the girls, personally, I would ask that we go off YouTube while we're doing this line of questioning.
okay. I will stop the live stream regarding the question that has been posed and the answer that Mr. Solis attempted to give. And let's cover this ground as quickly as we can, and then I'll restart it as to other concerns.
Yes, ma'am.
Okay.
Thank you, Your Honor.
Okay, it is live streaming again. Okay.
Mr. Solis, when's the last time you had contact with the girls?
I don't have personal contact. They have contact with my mom.
But you've had personal contact at least some point in the past, correct?
Oh, in the past, yeah, I thought you meant recently. Yeah, the last time I saw them was in 2020, in the summer of 2020.
And that was right before you were incarcerated?
Correct.
Okay. And what was your visitation situation with them like then? Were you seeing them consistently?
No, when I saw him that one time, it was just a spur of a moment due to the mom going to my mom's house.
Okay. In the past, have you had difficulty with Miss Pineda allowing you to visit your children?
Yes.
Okay. And has she refused you sometimes, not based on the children's safety or anything, but based on arguments you two were having with one another?
Based on arguments about, based on arguments of parenting issues.
Okay. So you two have had some disagreements in the past on parenting?
Yes, we have had numerous disagreements.
Okay. And when she disagrees with you in the past, has she withheld your children from you?
No, yes, that's the go-to move.
Okay. Does that cause you concern moving forward as well, that you would have a lack of information in the event that your children did need to be protected by a third party, even if it's CPS?
That and it also, I believe it messes them up psychologically because they don't hear both sides of the
Your
story.
Honor, speculation.
Okay, I'll sustain. It's speculation. You can ask another question.
Thank you. Do your children, well, I guess prior to the removal, were they still seeing your mother frequently?
Because we live in two different cities, they don't see them, but they would see, not physically, but they would see them through Zoom or FaceTime or phone calls, mostly phone calls and FaceTime.
Okay. So when you saw him in 2020, she just happened to take him through where your mom lives, I'm assuming in San Antonio, is that right?
Yeah, she took him to my mom's house.
Okay. But that hasn't happened since 2020, as far as you know. Like, I know you haven't seen him, but your mom hasn't seen him since 2020 either.
No, she just barely was able to start having a Zoom visits with the girls, probably about like 4 months ago.
Okay. And regardless of what the court does, are you asking that they be allowed to continue to have some sort of contact, even if it's FaceTime visits, with your mother?
Yes, I would really appreciate that.
I'll pass
She
it
does
on.
provide, financial, she's elderly, she's 80-some years old, so she can't physically take them in, but, she does help them out with financial, and, we used to not miss a birthday or Christmas, but, lately we've been missing them due to the mom's choices, not because of we disown them or abandon them.
Yeah,
We've never done that.
I'll allow it. I'll overrule. He's finished his answer.
I'll pass it on to Oh, I'm sorry. Mr. Solis, did I forget something that you wanted to address to the court?
No, just that we've never abandoned them. We've just had to always play by the rules, whatever setup that Anna felt like, and I guess whatever Anna wanted to go, whatever rules Anna applied, we had to go through that, and we couldn't really do anything. We couldn't fight it. So we just try to make peace, and my mom is the go-between. There was always a lot of respect between her and my mom. So the kids know about my mom. And like I said, we used to not miss Christmases and
Objection,
Thanksgiving.
Your Honor.
Okay, we're getting into the narrative now, but
Okay.
I understand what you're saying, Mr. Solis. I hear you.
Sorry.
Okay, Mr. Morales, anything further?
No, Your Honor.
All right, Ms. Zavala.
Mr. Solis, if I understand you correctly, you're concerned about Anna allowing people around who might abuse your children or expose them to drugs.
You have a real bad echo. I'm having a hard time hearing you, ma'am.
If I understand your testimony correctly, you are concerned about Anna allowing people around your children who might abuse them or expose them to drugs, correct?
Correct.
Okay. And you are currently incarcerated for methamphetamines, correct?
Correct.
And you've previously been incarcerated for striking your 2-year-old son.
Correct.
I'll pass the witness.
All right, Mr. Trout, back to you. Any follow-up questions?
No follow-up at this time, Your Honor.
Okay, anybody else have any further questions they want to ask Mr. Solis at this time?
Very briefly, Your Honor.
Go right ahead.
Thank you. Since the pendency of this case, do you have any personal knowledge of progress that Ms. Pineda has made?
No, I do not.
Do you have any personal knowledge of services she's worked to mitigate the reasons for removal?
No, I do not.
I'll pass the witness, Your Honor.
Okay. Anybody else have any questions for Mr. Solis?
No questions this time, Your Honor.
No, Your Honor.
All right. All right, Mr. Trout, we're probably going to take a short break, give Ms. Corbin a little break here.
Yes, ma'am.
Who's your next witness going to be?
Call Ms. Hoganson back to the stand.
Okay, yeah, this would be a good time to break because she's probably going to be a little bit longer witness, I suspect. So, okay, let's just take 5-10 minute break. Let everybody get up, move around for a few minutes.
Yes, ma'am.
Okay. All right, Mr. Trout, you can call your next witness.
Call Ms. Hoganson back to the stand, Your Honor. Ms. Hoganson, you've been here for testimony, correct?
Correct.
And when St. Francis first receives a case, do y'all build what is called family plans of service?
Yes, sir.
And Mr. Morales had asked you a couple of questions about the family plans of service earlier, correct?
Yes, sir.
Okay. Tell us, what are family plans of service?
Family plans of service are just a document that lists out different services for the parent to complete to mitigate the reasons for removal.
And was that done in this case?
Correct, yes, sir.
Okay. And are family plans of service made in order of a court?
Yes, sir.
And were they made in order in this case?
Yes, sir.
Did you receive what I sent out, exhibit number 4?
Yes. Let me pull it up. Okay, got it.
And do you recognize that document?
Yes, sir.
Okay, and what is that?
That is the family plan of service for Neil Solis.
And was this family plan filed with the court in this case in November of 2023?
Yes, sir.
And were the family plans of service made in order of a court in this case?
Yes, sir.
And does this document, has it been altered in any sort of way?
Can you repeat that?
Has this document been altered in any sort of way?
No, sir.
This is an accurate copy of the family plans that were for Dad, Neil Solis.
Yes, sir.
Your Honor, I'd ask to admit exhibit number 4. It's the file marked copy of the family plan of service for Mr. Solis in this case.
Any objection?
No objection?
No objection.
All right, petitioner's exhibit 4 will be admitted.
Thank you. Ms. Hoganson, during the course of the case, what was Mr. Solis asked to do?
He was asked to do report to a St. Francis Ministry permanency specialist. Let's see, participate in a parenting course, participate in and complete any relevant and beneficial classes offered while he is incarcerated. And then of course, employment and stable housing, but that doesn't really pertain here since he is incarcerated.
To your knowledge, has he worked on any of these or tried to do any of these services?
He has tried to do parenting, I believe. But I haven't received any completion of any services.
Okay. So just based on your knowledge, you're unaware whether he did or did not complete that service?
Correct, yes, sir.
Okay. Do you know, has he attempted or tried to do any other services while incarcerated?
Not to my knowledge.
Okay. And you had testified earlier that you had reached out to the prison to try to figure out what he could do and couldn't do.
Yes,
correct?
sir.
Okay. Prison just never got back to you on any of that?
Yes, sir.
Okay. Do you know whether Mr. Solis, while incarcerated, has done his own inquiries and what he could and couldn't do?
I'm unsure.
Okay. But throughout the pendency of this case, you've never received any certificates of completion of anything he did while incarcerated?
No, sir.
Okay. You heard the testimony earlier and have seen the exhibits admitted in the evidence. Is the department asking today that the court award the department PMC, permanent
Correct.
change in conservatorship,
Yes, sir.
award mom possessory conservatorship,
Yes, sir.
no child support or medical support at this time,
Correct.
in the continuation of working with mom, if at any time she tests positive for alcohol or any type of drugs, that her visitation would be pulled
Yes, sir.
back to supervised.
Yes.
And this is all in an effort to ensure the safety of the children if they are eventually returned to mom and what we are working toward.
Yes.
Okay. And you believe that's in the best interest of the children?
Yes, sir.
And as to dad, are you asking the court to terminate the parental rights of Neil Solis as to both children, Alyssa and Annalisa, based upon 161L01L, which is the, he has a prior conviction for the injury to a child.
Yes, sir.
And also Q grounds that he is incarcerated from 2 years from the removal,
Yes, sir.
and unable to provide for the children.
Correct. Yes, sir.
And also for failure to work services, even though some of that may not be at his own.
Yes, sir.
And do you believe that's in the best interest of the children?
Yes, sir.
Tell us again how the children are doing.
Annalisa and Alyssa are both doing great. They do really well in school. They're both in extracurricular activities. Annalisa does track and football, and Alyssa she plays in the school band. They have been really enjoying all their visits with their mother. They enjoy their visits with their Aunt Linda. Everything's going good overall with them.
And is part of the concern also, and I understand Dad has possibility of parole. But we still have the concerns of that Dad still has convictions for injury to one of his children.
Yes, sir.
And as Mr. Morales pointed out, once, if Dad does not get paroled, the children will be over 18 and can decide what type of relationship they want with Dad at that point. Is that correct?
Yes, sir.
But at this time, the best interest of the children, in your opinion, would be moving forward with PMC with the department to allow Mom to continue working to try to solidify the safety of the children before returning.
Yes, sir.
I'll pass the witness, Your Honor.
Ms. Kincaid,
No questions, Your Honor.
Mr. Morales.
Thank you, Judge. Ms. Hoganson, have you been the permanency specialist for the entirety of this case?
No, sir.
When were you assigned?
I would say mid-July of last year.
Okay. So about, I guess my math isn't perfect here, what, 9-10 months?
About.
Okay. And you stated that when you were in contact with the WIN unit, you were supposed to receive a call back from the individual in charge of coordinating with CPS.
Yes, I believe so.
But I think you testified that you had made 2 attempts to contact this individual.
Yes.
Okay. Are you aware of whether or not the previous permanency specialist made any attempts to contact this individual?
I'm not sure.
Okay. So all we're sure of today is that in a year and a half, there's at least been only 2 that we know of attempts to contact TDCJ to get Mr. Solis to work services. Is that correct? That's all we're aware of today.
That's my understanding, yes.
Okay. And you are also aware though that parenting is at least one thing is available at the WIN unit?
Yes.
Do you know what else was available at the WIN unit that you were trying to get set up?
No, sir. It was only the parenting that I was aware of.
And has Mr. Solis made it continuously clear to you that he wanted, not only was he willing to, but he wanted to participate in that?
Yeah. Yes, sir.
And were you made aware by anybody, whether it be Mr. Solis or the jail, that the only way to accomplish that is by and through the jail? So in other words, you can't just send him a packet, him fill it out and send it back. Is that correct?
Yes, I was made aware of that.
Okay. Would you agree with me that there's a bit of a lengthy history with these children as
Yes.
far as CPS care?
Yes, sir.
Okay. And as of today, the department's not prepared to ask the kids to return to Mom today, correct?
Correct.
So would it be safe to say that there's still at least some residual concerns?
I would say the only concern is her not having her license and then the financial stability.
If the court were to order that Mr. Solis had possessory conservatorship and absolutely no contact, no visitation whatsoever, and just kind of wait and see, just to keep his parental rights intact, at least for him to modify, what concerns specifically in that circumstance would the department have with Mr. Solis endangering the children at all?
I'm unsure.
Now you made mention through Mr. Trout's questions about the previous endangerment. To be clear on the record, his previous charge, Mr. Solis's previous charge against one of his children, that was not against either of these two girls that are subject of this suit, correct?
Correct.
And again, you'll have to forgive me for being behind. The girls, as far as I've read, they don't have any kind of developmental delays or anything like that. They're not in special education or anything like that.
No, sir.
And have you had an opportunity to speak with them?
Yes.
And in your opinion, would they be able to express to you themselves like safety concerns and safety issues?
Yes, sir.
So if potentially dad did come around, they would at least be able to, whether or not they'd be willing, that might be speculative, but they would be able to express that intelligibly to somebody, whether it's CPS, a counselor at school. They would be able to say, hey, dad's doing this, dad's trying to pick me up. You think they would, or they're at least capable of doing that?
I think they are capable. Yes, sir.
Okay. I'll pass the witness.
Ms. Vaughn.
I have no questions, Your Honor.
All right. Mr. Trout, any other questions for this witness?
Judge, did Ms. Kincaid get her option? I didn't hear. I can't remember if she.
I think she did. I think she said no questions, but
That's right. I couldn't remember. Sorry.
Yes, I don't have any questions.
Um,
Or I guess now it's Mr. Trout's turn and I can follow up after him.
okay. Hey, we lost somebody. I heard.
It may be Miss Pineda.
Yes. All right. Everybody just hold tight till she gets one back in. Okay, we've got her back.
Sorry.
No, it's no problem. Can you hear us? You can hear us okay? Okay. All right. None of us choose when the internet decides to go on the kaflutz. All right.
I do have just a couple of follow-up questions, Your Honor.
All right, you may go right ahead.
Thank you, Your Honor. Ms. Hoganson, as far as contact with that, I know you stated that you tried to get in touch with the prison a couple of times. Has there been a family support worker on this case?
Not during the time that I've been on it. No, sir.
Okay. Has there been a courtesy worker anybody sent to the prison?
Yes, sir. A courtesy worker.
Okay. According to your reports and stuff, has dad met with the courtesy worker?
He's met a few times with her, but recently has been refusing visitation.
Okay. And when you say visitation, you're talking about with the family support or the courtesy worker?
Yes, sir. Correct.
Does your records state why?
No, sir. Just in her documentation, it says that Mr. Solis refused to visit with her.
Okay. And what were you sending courtesy worker to the prison for? What were they doing?
The courtesy worker was to have the monthly face-to-face visit with Neil Solis and just give him information on the case and see how he's doing.
Okay. So there have been attempts to keep them updated and to try to work with them through a courtesy worker that could see them in person.
Yes, sir.
And you stated as of late, since when has he refused? Do you know?
Not off the top of my head. I know this year for the last couple months he has refused though.
Okay. Thank you, ma'am. I'll pass the witness, Your Honor.
All right, Ms. Kincaid.
Thank you, Your Honor. Earlier, Mr. Morales asked you if you would have any concerns about Mr. Solis' parental rights remaining intact. Do you recall that question?
Yes, ma'am.
Based on his previous criminal record and his current incarceration, would you be concerned if he were to be released about the children's safety?
Yes, ma'am.
Thank you. I'll pass witness.
All right, Mr. Morales.
No questions, Judge.
Ms. Zavala?
Ms. Hogerson, Mr. Morales earlier asked if the injury to the child was with these two girls, correct?
Correct. Yes, ma'am.
The injury to the child from Mr. Solis was to his 2-year-old son. Is that right?
Correct. Yes, ma'am.
Are you also the caseworker for that child who's in a different case?
Yes, ma'am.
Okay. Is that child continuing to suffer from a TBI from that injury?
Yes, ma'am.
I pass the witness.
All right, Mr. Trout, anything further?
Nothing further, Your Honor.
All right, then. Anybody else have any other questions for Ms. Hoganson? Just
No, Your
give
Honor.
everybody one last shot.
No, Your Honor.
Okay, then. All right, Mr. Trout, any further witnesses?
No further witnesses, Your Honor. I would ask, for the court to take notice of something on one of the exhibits. If it's kind of a follow-up to what Mr. Morales and Ms. Zavala just spoke about. In the prior case, that was the injury to the child. If the court would take notice at the bottom of page 2 of the judgment, due to that conviction, there was a no contact with both girls in regards to that case. So they were around, and there was protective measures put in place for these two girls and mom at the time of that conviction.
Okay, give me just a second to
And
look for it.
That's on page 2 of the judgment, just above the judge's signature. It states, furthermore, the following special findings. And that's on exhibit 1.
All right, counsel, any objections?
No objections, Your Honor. It's been admitted.
No objection.
No, Your Honor.
All right, then the court will take notice of the special findings and orders in that judgment, that there is no contact with the two children that are the subject of this suit and the mother. There is another child named, but he is not the subject of this suit. Okay.
And with that, Your Honor, I have nothing further.
Is the department rest?
Department rest, Your Honor.
All right, then, Ms. Kincaid, any witnesses to call today?
Yes, Your Honor. I'd like to call Ms. Pineda, please.
All right, Ms. Pineda, if you'll unmute for me. Raise your right hand. Do you solemnly swear or affirm that the testimony you'll give today will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. All right, you may proceed, Ms. Kincaid.
Thank you, Your Honor. Ms. Pineda, have you heard Ms. Hoganson's testimony today?
Yes, ma'am.
Do you recall that we entered into a mediated settlement agreement back in September?
Yes, ma'am.
And in that mediated settlement agreement, we agreed that the department be named permanent managing conservator. Is that correct?
Yes.
And in that agreement, back in September, you were willing to pay child support. Is that correct?
Yes, ma'am.
Since that time, there have been some material or substantial changes. Is that correct?
Yes.
You've made a lot of progress and have worked really hard to continue to work toward reunification. Is that fair to say?
Yes.
And one of the things that would be helpful for you to overcome your last barrier to reunification would be not to be ordered to pay child support. Is that correct?
Yes.
And so are you asking that the judge waive that particular part of the mediated settlement agreement?
Yes.
But other than that, you're willing and happy to continue to work with the department toward reunification?
Absolutely.
Okay, I'll pass witness.
All right, and just as a clarification, was it child support? Was there any medical support in there? I'd have to. pull
Yes,
it
Your
up
Honor,
again.
there was. I believe it was $50.
Okay, all right. Is the request then as to child support and medical support?
Yes,
Yeah.
Your Honor.
Okay, that's what I thought I'd understood, but I just wanted to be clear. Okay. All right, Mr. Trout, any questions for Ms. Pineda?
Just a couple, Your Honor.
Sure.
Ms. Pineda, safe to say you've had a few ups and downs in the last few years working with the department. Is that correct?
Yes, sir.
But here in the last while, you've been able to keep things on track.
Yes.
And at this time, are you committed to working toward getting your children back and providing a safe environment for them?
Absolutely. 100%.
And you understand the concerns?
Yes, sir.
And you understand why at this point, the department's not requesting to just hand your children back to you?
Mm-hmm.
And we still
Yes.
have a little work to do, correct?
Yes.
But you are committed to doing that work and to eventually be able to have your children back in the home to provide that safety for them.
Most definitely.
I'll pass witness, Your Honor.
Okay, Mr. Morales?
Just briefly, Your Honor. Ms. Pineda, you stated that you understand why the department still has concerns with your situation and some of the history. Do you understand that Mr. Solis, he had testified that he also has continued concerns? Did you understand that when he testified that?
Yes.
And likewise, do you have concerns if he were released?
Yes.
Okay, what concerns do you have specifically if he were released?
Keeping my kids safe. That's all I've done is keep my kids safe. After him hurting my son and my daughter, I don't want to take any chances.
Okay. Now you stated that all you've done is keep your kids safe. Now you're stating that from what time? Your testimony today is that you've always kept your kids safe?
I mean, I'm not perfect, but I mean, he almost killed my son.
Okay.
Oh, wow.
Well, your daughters, when they are in your care, when you visit them, do they appear to be honest with you?
Absolutely.
Do you think that in the event that Mr. Solis was coming around or trying to contact him, if he did get out, do you think that they would notify you right away?
Absolutely. I've always let them make their whatever choices or feelings that they have. They're more than willing to express those.
I believe Mr. Solis had stated that you took the kids to San Antonio like in 2020. Is that correct?
I don't believe it was 2020. I think it was a little bit later than that. Maybe like 2019, 18 maybe. Because I think the pandemic happened in 2020 and no one was doing anything around that time.
And was that to visit him or was that to visit his mom?
His mom.
Are the girls close to his mother?
No.
Okay. He stated that he said that the girls stated something along the lines that they were still open to have a relationship with him. Is that your understanding at all?
No. From what my daughters told me, I guess his mom keeps asking and they feel bad not telling her No.
I'll pass the witness, Judge.
Okay. Ms. Zavala?
Your Honor, I have no questions.
All right, Ms. Kincaid?
No further witnesses, Your Honor, I'd rest.
All right, thank you. Okay, Mr. Morales.
Your Honor, I have no witnesses at rest.
All right, Ms. Zavala, any witnesses today?
No witnesses, I rest.
Okay, Ms. Zavala, do you have a recommendation to make to the court?
I do, Your Honor. Throughout the course of this case, I've met regularly with the girls, and as recently as this past Saturday. Based on the evidence that was presented and my discussions with the girls, I do believe it's in the best interest for the department to be named permanent managing conservator, for Ms. Pineda to be named the possessory conservator, to not order child support at this time, and to continue working with mom towards that reunification. I also believe it's in the best interest of the girls for dad's parental rights to be terminated at this time.
And Ms. Zavala, do you have a recommendation regarding mother's request about child support or medical support?
Yes, I think that should be waived. And I believe everybody's who was a party to that agreement is in agreement on that. And I do believe that's in the girls' best interest at this time.
All right, thank you. Okay, Casa.
Thank you, Your Honor. I have met with the girls as well, and they're doing good, as everybody's reported. They enjoy their visits with their mom. They have fun with her, and they tell me that they love her and they want to go back with her. So my recommendation is for the department to continue, or to be granted PMC, mom possessory, mom not ordered or be made ordered to pay child or medical support. And for her to continue working with the department to reunify her with the girls. And then I also recommend for Mr. Solis's parental rights to be terminated based on his criminal record, him not working in services, and then the no contact with the girls.
All right, thank you very much. And as always, thanks to CASA for their contribution to this case and for everything that you do for these two children and for all of our other children for that matter. But specifically, thank you for your assistance in this case. All right, everybody give me just a couple minutes. Okay, at this time, I am going to name, excuse me, the Department of Family and Protective Services as the permanent managing conservator of Alyssa and Annalisa Solis. I will name the mother, Anna Pineda, as a possessory conservator of the children. And I will not order any child support or medical support to be paid by her at this time. And find that she needs those resources to continue to work towards reunification in the case. Along those lines, I will order that she would continue to work any remaining services to achieve reunification as contemplated in the MSA. I mean, my understanding is that she's worked her services, but we still have those things listed as services, which, maintaining a job and housing and the stability and transportation. So those are really the things that I'm talking about here. Mother's visits will be according to our current position in this case. In other words, where we are now, not necessarily where we were back in October at the time of the mediated settlement agreement. I mean, there's been some significant changes since that time, so I'm not expecting that mother would move backwards to what existed at that moment in time. Obviously, when you all did that agreement, you weren't reading my mind about whether an extension was going to be granted in the case or not. So the objective is not that we're backing up to that point. We'll follow the spirit of that, but we need to look at where we are right now with that. Okay. I find by clear and convincing evidence that it is in the best interest of the children, Alyssa Solis and Alyssa Solis, to terminate the parental rights between the children and their father, Neil Andrew Solis Sr., based on Texas Family Code Section 161.001 B1 L, O, and Q grounds, and the best interest of the children under 161.001 subsection B2. At this time, I will dismiss Mr. Morales from the case. Ms. Kincaid will remain in the case as Ms. Pineda's attorney. Ms. Zavala will remain in the case. And just for the record, it appears, Mr. Morales, that your client has exited the proceeding. So.
Okay, Your Honor, I was gonna let him know that he indicated to me that he was likely gonna want to appeal this, and I was gonna let him know that it's gonna be a waiting period before the judges, but before the order is actually signed. But if he hung up, then okay.
Okay, so Ms. Kincaid will remain as mother's attorney. Ms. Zavala will remain as the children's attorney, and I would like CASA to remain in the case if they're willing to do that.
Yes, ma'am, we will.
Okay, I'd like that additional support for the children and resources available. All right, then, counsel, as Mr. Morales was alluding to, do be mindful that your de novo timeframe does begin to run as I've rendered this judgment in open court. And also, if you're instructed to appeal the case, then please do not file that notice of appeal until a final order has been signed and adopted by the referring court. Causes all kinds of consternation down the hall. Okay, anybody have any questions?
I have one quick question, Your Honor. As far as the visitations with mom, I know you said in the spirit of what we're doing now, moving forward.
Yes.
There was the request that if we have an issue with mom testing positive, anything that we can move back to supervisor. We're okay to do that if that happens. Hopefully it doesn't, but.
Yeah, absolutely.
Okay.
Yes. I mean, it's part of why we found ourselves here. So
Yes, ma'am.
yeah, it's a big issue. Yes. We clearly would have to pull back in the event that would happen. But Ms. Pineda, I am rooting for you. I'm pulling for you, just keep up the good work. And
Thank you, ma'am. Thank you.
You've got lots of people in your corner that want you to succeed. So,
Yes, I do.
nobody wants that any more than I do. So
Thank you. Thank you so much.
I know it's been a long road and but we've got to be sure that we're on solid ground.
Absolutely.
Before we send the kids home. So
yes.
Okay. All right then. Appreciate everybody's time this morning, particularly Ms. Corbin. Thank you very much for jumping on board with us. We really appreciate you. Just for the record, Mr. Morales, your client is not logged back in, so it appears that he voluntarily left and not that he had a phone issue where he dropped out. So anyway, we will go ahead and adjourn.
Thank you.
All right. Thank you all very much.